involved up to the highest military levels in downing MH17. And this brings me to the third point that concerns this trial. And the relatives realize that, formally speaking, and in legal terms, the Russian regime is not the accused. But for the relatives, de facto, the Russian regime, indeed, morally speaking, is standing a trial in these proceedings, and that has to do with the fact that two relevant questions in these proceedings are linked to the undisguised involvement of Russia, namely the question about the origin of the Buk missile that shot down MH17 and the question concerning the firing site. And the answer to those questions is much more evident now to the relatives than before Russia's invasion of Ukraine. And the answer to those questions obviously have to be formulated by your court after a fair trial. And the relatives understand and acknowledge that Pulatov's defense must have every opportunity to conduct a defense as they see fit, because only with a fair trial will the relatives be presented with the truth and justice that they are so looking forward to. Thank you.
Thank you. Okay, and now the court will resume the hearing. Well, yes, all of us here on the bench, prosecution, defence, and counsel for the relatives have shed light on recent events from their own angle of things. And I think in summary, we can see that some things which might seem so obvious to us are not always obvious. That we must maintain the guarantees here. Okay, ladies and gentlemen, on the 22nd of December 2021, the court suspended the hearings on the Girkin, Dubinsky, Karchenko and Pulatov cases until today, the 7th of March 2022. The court is sitting again in the same composition, and we hereby resume hearings on these four cases. As you saw, that one of us is present online today. We also have with us Mr. Newscater and Mr. Van Eyck, counsel for Mr. Pulatov. I'm now asking you whether you have specifically been authorized. Reply yes. Thank you. This means that the criminal trial against Pulatov now continues in interlocutory proceedings. The court also notes that counsel for the relatives are present and also relatives. In addition, investigating judges and members of the press, welcome once again, everyone. The court notes that defendants Girkin, Dubinsky and Karchenko have not appeared. They have been informed of this hearing, and the trial of these three defendants therefore continues in absentia. These four cases are still being heard simultaneously, but are not joined. Now, the practical side of things is the same as in previous occasions, except that, as you've already noticed, a great many COVID rules have now been scrapped. The hearing can be followed on a screen in other parts of the building. As before, there is a live stream. You can follow the proceedings in Dutch and English. As before, picture and sound recording during the hearing are not permitted. Last December, the prosecution set out its sentencing requests. In the forthcoming hearing block, the defense of defendant Pulatov will have the opportunity to plead in his case. The next 4 weeks have been set aside for this, that is to say Monday, Wednesday and Friday each week, a total of 12 days. Before I give defence the floor, there's a few preliminary comments to be made. At the beginning of the hearing block on the 8th of December 2021, the court noted that the prosecution had sent to the Russian authorities a letter of request, asking for the summons to be handed to Girkin, Dubinsky and Pulatov for all forthcoming blocks of hearings. And on the 8th of December 2021, no response from the Russian authorities had yet been received. Now, in the Pulatov case, the summons was issued to his counsel, who had previously agreed to that. In addition, his counsel were present at the hearing, and they confirmed that they had explicitly been authorized to act on his behalf. Documents received by the court on the 9th of February 2022 show, however, that the Russian authorities had issued the summons to Pilatov in person on the 17th of December 2021. Regarding defendants Gherkin and Dubinsky, on the 8th of December 2021, the court noted and ruled that the summons had been sent to the Russian authorities in the correct way, and that therefore the hearings in the Gherkin and Dubinsky cases could continue in absentia. Documents received by the court on the 9th of February last from the Russian Federation reveal that the summons addressed to Gherkin and Dubinsky could not be served because it did not appear to hearings at the competent Russian courts. Gherkin was summoned for hearings on the 22nd of December 2021 and 17th of January 2022, but he did not appear. Thereafter, a summons to the hearings was sent to his home address in Russia. Dubinsky was summoned to a hearing which he was informed of on the 20th of December 2021. He did not appear at the hearing. Thereafter, the summons to the hearing was sent to his home address in Russia. This brings me now to documents regarding S45. The investigating judge authorized the public prosecutor on the 28th of October 2021 not to add certain documents regarding witness S45 to the file. On the 20th of December 2021, the court rejected a defence request of the 8th of December 2021 for all documents regarding witness S45 to be handed over. The court observed at this stage that, in brief, they assumed that the investigating judge's decision on the 28th of October 2021 included the file on special investigative powers. On the 14th of January 2022, the prosecution informed the court that that was not the case. The court responded, in a letter of the 18th of January this year, that it considered the documents to be intrinsically relevant. Prosecution, in response to this, sent the documents to the investigating judge with the request for permission not to add them to the file, and the investigating judge gave permission. The request, in response to this and a report on its application, have been put in the 8th supplement to the file. Now we come on to the additions to the case file in December last year and February this year. The prosecution has added a number of documents in the 7th and 8th supplements to this case. These were documents which were added on instruction of the court after the 2nd of November and 8th of December hearings last year. Additions to earlier drafted procedural documents, an overview of what Pilatov's defense has seen. There are also recent reports published on the internet, that is to say, defendants Gherkin and Dubinsky's response to the sentencing request, and reports regarding the request and instructions for the use of special investigative powers which had not yet been put on file, but which the prosecution should have put on file. These documents were also made available to defence. The court now hereby adds all documents to the cases of all 4 defendants. This brings me to the injured parties' claims. The Counsel for the Relatives sent a letter on the 18th of February 2022 in reply to the court's outstanding question of why the Counsel for the Relatives considers the fact of parents and children living together being relevant to the level of claims, but not relevant to the level of damages for spouses and partners. The reply from the Counsel for the Relatives, as the court understands it, is that the difference is justified because children living with their parents have a stronger bond than children who don't live with their parents, since the latter have normally developed more independence, gradually focusing more on their own partners and families. No such natural development is normal for married couples, said counsel for the relatives. In addition, this letter submitted a number of further documents underpinning the claims already submitted. Finally, the public prosecution provided additional information regarding a claim first submitted to the prosecution and then sent to the Counsel of Defence on the 13th of April 2021. Further information was supplied to justify the claim and a level of compensation specified. Since that had not been happened previously, the prosecution will respond to these claims in its reply. These documents concerning the injured parties' claims are hereby added to the files of all four defendants. And now it is time for defence to begin their pleading in the Pulatov case. As I said, this will take 12 days. These days will, as normally, start at 10 a.m. The court will agree with defence on a day-by-day basis about when proceedings should be interrupted. We will seek to finish no later than 5 p.m. And here I would just add that essentially the morning and after sections will also be have a break in the middle, and that, generally speaking, each speaking session will last 3/4 of an hour or an hour, though of course it will depend on exactly how the pleadings proceed. The contents of the file have been discussed many times in the last 2 years since this case began. As follows. The prosecution presented its investigation in June 2020, when defence presented their requests and prosecution responded in the months thereafter. During the hearing of the case on the merits before the court, and prosecution's additional statements in June and November 2021, and finally, during prosecution's address and sentencing request in December last year. The same will apply to the pleadings that we will be hearing in the coming weeks. The contents of the file will be under discussion at that stage. The court notes that the substance under discussion may be distressing for listeners. However, it is necessary to face the facts. The court therefore again calls everyone's role in this criminal trial to be respected. As said earlier, any person in the chamber is free to leave the chamber at any stage if they wish. Finally, I would just say that at 12 o'clock, the alarms will be tested outside. I don't think we will hear the alarms here in the chamber, but if you do hear sirens at 12 o'clock, bear in mind it is a test. I will now give the floor to the defence.
Thank you, Your Honour. First of all, allow me to explain how we've organised things with our pleading notes and everything before I actually start with the oral arguments. We have 9 sections or parts of the oral pleadings in hard copy here. My colleague is copying everything. This is only a small part of everything. We don't have any copies as we speak for the counsel for the relatives, but we'll be presenting with them with those oral pleadings today. And I was wondering whether it would be appropriate to provide you with a digital version for the judge who's in quarantine and I'll leave that to the bench, of course, but in the break we can ask someone to send our pleading notes by email, because it's important that the judge who is confined, I'm deliberately not saying the COVID judge, but I think it's important that she also receive a digital version. The President of the Court says, I'm just looking at the clerk. President of the Court, someone of communication will arrange for that, the communication department. All right, says counsel. Let me first distribute the version, the hard copy that we have available here. Council. I hope everybody can hear me, also in the public gallery. Probably if they can't hear me, I'm sure someone will say. So, President of the Court, Your Honours, members of the public prosecution, members of the Council for the Relative, ladies and gentlemen, let me first of all point out what it is that we plan to do today. First of all, I shall provide a brief introduction to the preface, really, and in this introduction, I shall also respond to what was said just now about the current events. I shall do so from a slightly different perspective. I'll say a few words about fact-finding, and I shall also indicate what the structure of our oral arguments are. That may be interesting also for the members of the press present here today. And in my preface, actually, I am going to address 6 topics. First of all, the first topic that I have called parallel investigations. So we not only have the criminal investigation in this case, but we also have other investigations that have been conducted in this case. And I would particularly like to highlight the impact thereof on the what we call the primo investigation. And then in the next chapter, I shall discuss the context of this trial and the expectations. And then I shall discuss our position that no fair investigation has been conducted into alternative scenarios, and I'll be commenting on that later on. And then there's a subsequent chapter focusing on the restrictions that we're facing in this investigation. And then I shall provide a brief analysis of the different sources of evidence that we find in the case file. And then in conclusion, I shall say a few words about the attitude in the proceedings of the public prosecution in this case. After my introduction, I shall outline the schedule for our oral arguments, so how we've structured things. So today, Your Honours, it's almost exactly 2 years ago, still 2 days to go, but it's 2 years ago that this case was first called out in this court building. And now, in the meantime, we know that the public prosecution is aiming very high with a lifelong imprisonment requested by the prosecution for our client. The prosecution is demanding the highest possible sentence in the Netherlands, not only because of this request for sentencing, but also, as far as we're concerned, in view of the very impressive and powerful hearing days in September and partially in November 2021. Because of that, this case has acquired a dimension that requires the highest level of professionalism from all participants in these proceedings. And all the impact statements in September 2021 made it extremely clear that it is of the utmost importance to determine the actual course of events of this crash, however painful that may be. During our oral arguments, it'll become clear that we still seriously question the scenario as presented by the joint investigation team and the public prosecution. And we shall explain our position in this respect in further detail at a later stage. Explaining our position is in line with our role and our position in this criminal trial, and by the way, also reflects a sincere legal feeling of unease that we have, meaning that we still do not know what exactly happened. Every time we assess the evidence that is submitted, we cannot help but think that there must be more relevant facts, circumstances, and/or events concerning this crash, unbeknown to us. The available forensic evidence and the way the investigation was conducted in this case gives rise to this feeling for too many reasons, as far as we're concerned, and we will also be explaining this in further detail. We would like to emphasize once again that with our explanation we aim to contribute to fact-finding, always conscious of the unimaginable grief as expressed in such a respectful and admirable way last year. And now there is the grief and suffering caused by the war that is being waged in Ukraine. And naturally, we understand the sentiments that prevail in this respect, and we should also try to keep that in mind in our oral arguments. And also for those reasons, some parts of our oral arguments will only be presented in a summarized form, and the substantiation of those arguments will be included in an annex to our pleading notes. This annex shall only be presented to the court, prosecution, and counsel for the relatives. And we have informed the court of this way of working, which in our view is necessary. So we have discussed it prior to the hearing with the court. The previous chief public prosecutor who was involved in this investigation said in an interview in 2020, and it was said just now, that de facto the Russian regime in this trial is in the dock. That has been said, but that's not the case. Not even de facto. We are defending, as counsel, Mr. Pulatev, and in this courtroom, we are not representing his country. What we present in our oral arguments is completely separate from recent developments and events, and in terms of substance is no different from a situation in which the accused would be a Dutch citizen. And this is the context in which you should interpret our words and our positions, and particularly legally speaking, we will mainly address your court being the body that will hand down the sentence in this case. We do realize that current events may cast a shadow on the events in July 2014, but that wouldn't be right. Now, in 2022, this situation, the events today, should be seen separate from the events in July 2014, and it's not unusual that subsequent events overtake a criminal trial and that all parties in a proceedings have to cast their mind back to the circumstances and the zeitgeist of 7 years ago. And the current events are in no way indicative of what happened in 2014. Casting our minds back is not easy, not a simple task for any of the parties in this proceedings, and especially not for us. And our task is, if anything, even more complicated now, but we will not shy away from that, and we do realize that many people will simply not understand And this task or duty, as I said, means that we wish to contribute to the fact-finding with regards to the events in July 2014 and defending only Mr. Pulatov. And we must ask ourselves the following question: what is fact-finding, and particularly what is fact-finding in a criminal trial? Is it reconfirming a scenario for more than 7 years now by the public prosecution and the joint investigation team, as a consequence of which public opinion considers it to be the truth? Over the past few days, I read so often in the newspaper what the opinion is, also of journalists, about questions 1 and 2 in this criminal trial. It has become common knowledge, in fact, whereas you still have to hand down your judgment on this. Does fact-finding mean that you should earmark the facts, in this case, as misinformation or conspiracy theories, in order to make sure that no scenario is chosen that society would find very difficult to tolerate? Will fact-finding be complete if we go for the most probable scenario? Is fact-finding complete if alternatives are ignored, or if we turn a blind eye to those alternatives? Does the subjective faith in our own judgment guarantee our opinion, and does that conclude fact-finding? Is fact-finding complete if examining crucial witnesses becomes less important than administering justice within a reasonable period of time? And is fact-finding complete if, in evaluating a witness, one relies on what is printed on paper with respect to what the witness has said, or speculations about what the witness could say, without allowing the witness to speak for him or herself? And is fact-finding a search for a satisfying match or a feeling of coherence with respect to the facts that are presented? Besides these almost rhetorical questions, Your Honor, one must also realize that fact-finding in a criminal proceedings automatically implies reducing reality. Many factors in a criminal trial are responsible for reducing reality, and I shall mention a couple of them. Witnesses and the accused in a criminal trial have their own interests and will often act upon those interests, and that will clearly be at the expense of fact-finding. The court is bound to the indictment, and so the investigation into facts and the truth will have to be limited to that. That means that the substantive fact-finding will be reduced to the truth that is relevant for the decisions taken in a criminal trial. And the words of the public prosecution on earlier hearing days confirm as much, and I shall quote a couple of these statements. Fact-finding is of extreme importance in this case, but the indictment defines the limits of fact-finding, and the questions that do not fall within these limits are to be investigated outside this criminal trial. And then a criminal trial is not a comprehensive attempt to write history, but an investigation into the charges that have been put forward against the accused. And in this case, these premises lead, for instance, to the fact that there has hardly or not been an investigation into other scenarios. And another factor that leads to reducing the reality in a criminal trial is the following: the compilation of the case file, which is reserved to public prosecution, and the court and the defense cannot in equal measure contribute to such a case file. On several occasions, we raised the question in this trial: what is in the investigation file? What is in there that could make a contribution to fact-finding? We did not, or hardly, received any answers to those questions. What's more, public prosecution has said the following. And second, the defense is not Sherlock Holmes, nor is it the Inquiry Committee of the United Nations, but it's the voice of Pulatov. And fact-finding, in other words, is a legal responsibility of the public prosecution and the court, but not of the defense. And in the case at hand, this reduced reality that we just mentioned has become apparent, painfully apparent on several occasions, because we do not know, and these are the words of the public prosecution once again, because we do not know what the specific course of events was for downing MH17, how the crew acted, why the crew pressed the button. These are the words of the public prosecution, which I'm quoting. And another example in this respect are the questions that prevail about the role of Ukraine in terms of the actual reasons not to fully close the airspace on 17 July 2014. Those reasons are part and parcel of fact-finding, but are beyond the scope of this criminal trial. And all this makes clear that from the perspective of fact-finding, this criminal trial is conducted with blinkers on, and that fact-finding in this context is a relative notion that in fact is being downgraded to an artificial truth. In order to conclude this brief introduction, we would like to emphasize once again that we will attempt in our choice of words and our tone to be mindful of the feelings of the relatives, and at the same time we realize full well that in the eyes of the relatives we will probably not always succeed in this aim. For us as counsel, we are being expected to continue to look at the facts and circumstances described in the case file just as critically and with the same lack of bias as prior to September 2021. And this applies not only to the fact of the case, but also the legal aspects of the case and the horrible impact of what transpired on 17 July 2014 may not lead to a different legal assessment of the elements of the indictment. And literature also is very wary of that. There is an article about the illusion of the substantive truth, says the following. It is clear that there is no denying love is blind, and so the collective disgust caused by certain serious criminal offenses and the collective aversion of the monsters that have caused these events, at the very least, can cause impaired vision. And in order not to run any risk at all in this respect, for that reason, it seems appropriate to separate the the fact-finding in the criminal process from the normative concept of fact-finding in a criminal proceedings. And that way we can make sure that the scientific quality requirements are not affected by infected, fluctuating notions and unpredictable notions of reproachability and urge for retaliation and revenge. Your Honours, and the choice of words of the public prosecution in the prosecution's submission, unfortunately, in our view, this urge for retaliation and revenge becomes rather clear, and we trust that you are sufficiently familiar with the choice of words, and we're not going to repeat those words here. So after this introduction, I shall proceed to explain what the structure of our oral arguments is. Our oral arguments will start with an extensive preface in which we will show what the perspective is that we have with respect to the course of events in these proceedings and the impact for our defense, and also our perspective on collection of evidence and compilation of the case file. And in this preface, you will see the first contours of the defenses that will become more specific in due course, and we will frequently refer to this preface in our defense. Public perception requires, particularly in a case that everybody is following so closely, requires a very well-balanced and nuanced approach of what is described in the case file and in statements and reports. And if there's no such nuance, then we are forced to apply corrections and add information. After our preface, we shall first extensively elucidate what our view is of the question as to whether this here is a fair trial. We will then go through the evidence with respect to the questions formulated by the court, questions 1 and 2. And we will demonstrate that the outcome of the forensic investigation cannot lead to the conclusive evidence that a book missile caused the explosion in the flight MH17. We will also argue that other surface-to-air missiles cannot be ruled out. The fragments that originally would have a bow tie shape, and the tube that was found of the missile will all be discussed. And if nonetheless we would suspect that it was a book missile that was only available to Ukraine in July 2014. With respect to the firing site, we will demonstrate that it could never have been in the vicinity of Pervomaisky, even though there is, for instance, a video of a teller that leaves Snitsny. This video, of which no recording date has been established, says nothing about the question whether that is indeed where the missile was fired. The topics that we mentioned about the identification of the missile and the firing site will be discussed step by step and in detail in order to make it clear why we are taking the positions that are so different from the positions of public opinion. And to that end, it's necessary that our oral arguments be assessed in their entirety and not parts of the oral arguments. Our positions are not only quote-unquote defenses, but also represent our absolute conviction with respect to these topics. And we do not stand alone here, because the group that we commissioned, the group of American experts that we commissioned to investigate this, supports these views, and we will discuss the details when we discuss the topics. After discussing questions 1 and 2, we would actually want to conclude our oral arguments. However, in a criminal proceeding, the situation is different because counsel must also keep in mind that the court may not go along with all the points put forward in oral arguments, which is why we will also discuss the theoretical question that if the scenario of the public prosecution were to be correct, whether indeed then our client would have been culpable in his involvement. And before answering this question, we will also be discussing alternative scenarios that so far have been insufficiently discussed. And particularly, we will be highlighting the scenario that we now call the Ukrainian book scenario. And we will then demonstrate that Pulatov never played an active role in the events as specified by the public prosecution, so he should be acquitted on those grounds. And finally, our oral arguments will be closed by looking back on this criminal trial. And, Your Honours, in terms of schedule, that would be as follows. Today, we will discuss the preface, and then Wednesday, 9 March, we will be discussing the right to a fair trial. Friday, 11 March, we will be discussing missile identification, and we expect that on Monday, 14 March, in the morning, we will be continuing our oral arguments on that. And then in the afternoon of 14 March, we hope to be able to discuss context and supporting evidence with respect to question 2. And then we would continue that on Wednesday, 16 March. And then Friday, 18 March, we will be discussing all the calculations that have been made with respect to the firing site. After which, on Monday, 21 March, let me see, we will wrap up that topic with the available witnesses, and Wednesday, 23 March, the alternative scenario will be presented, and then on Friday, 25 March, we will address question 3, and we will then first start with the factual behavior, and then the following Monday, which is on 28 March, we will be discussing the legal qualifications in that respect. And if this planning still stands, then on Wednesday, 30 March, we will be presenting our conclusions, and then we have one extra day on Friday, 1 April, in case we need the time. So we hope to be able to follow the planning that we envisage. So for the time being, this is our planning. I assume you will inform us when it's time to take a break. Not necessary now, but I'm sure you'll tell me.
Well, I'm now going to start with the substantive part of our presentation. And the first thing I would like to talk about is the criminal investigation in this case and the context in which it took place and continues to take place. I'll be addressing investigations which took place in parallel to that of the JIT. So I'll basically be looking at what types of investigations took place, who was running those investigations, when they started, and what their nature was. I'd like to draw your attention to influence between one investigation and another, and just how little room remained for the Dutch Public Prosecution Service to run an exclusive investigation. Because normally a correct management of a crime scene and reliable evidence requires that a single authority, and under Dutch law that would be the Public Prosecution Service, takes place. So I'd now like to start off with the fundaments of Dutch criminal procedure. The site of a criminal investigation is of the utmost importance in ensuring that the outcome of investigations is reliable and that the evidence gathered is probative. At least that is the case in the Dutch criminal system. Indeed, no entity other than the Public Prosecution Service has the authority to open an investigation or to conduct an investigation, or indeed to prosecute criminal offences. And no other entity has the right to lead such an investigation. As regards oversight of an investigation, the rules are all set out in sections 141 and 142 of the Code of Criminal Procedure. It states that investigations must be conducted basically by Dutch prosecutors and Dutch police. And it is these individuals who may produce those official reports which are put before the court and have the value, or the value of evidence. Furthermore, there are rules regarding territorial jurisdiction. Basically, the police officer or prosecutor only has jurisdiction over the territory or on the territory for which he has been appointed. Basically, this means in the case of the Netherlands that the territorial jurisdiction is limited to the Netherlands in Europe. It is possible for the territorial jurisdiction to extend beyond the Netherlands if certain requirements are met, those of sections 539A, paragraph 3 of the Criminal Code. This can only be the case provided that it is allowed under international law and interregional law. Now, it is clear from parliamentary papers that when the Netherlands has jurisdiction and when the right conditions are met, it may have a legal basis for extraterritorial investigation. Once again, provided that international law and the relevant national law is complied with. And there is such a basis given the indictment in this case. Now, pursuant inter alia to Section 521, Paragraph 3 of the Code of Criminal Procedure, the JIT could provide the required compliance with international and national law for extraterritorial investigative powers to be exercised. However, it is necessary that, as per Paragraph 3 of Section 521 of the Criminal Code of Procedure, that the investigative powers to be exercised are set out in the agreement establishing the JIT. However, if we look at the JIT agreement, which is on the case file here, it basically states that the purpose of the JIT is to gather evidence regarding the crash and regarding the identification of the victims. It also states that the sovereignty of each of the parties is recognized, and any participation of a party in the investigative work of another party to the JIT must be exercised in line with the applicable national law. That's what the JIT agreement said. Now, of course, Your Honour, in my actual pleading notes that I've provided to you on paper, you will find footnotes that lead you to the references which underpin what I'm saying. Now, these parts of the JIT agreement are worded in general terms, and the specifics of the interterritorial investigative powers required under Section 5.2.1 of the Code of Criminal Procedure are, however, missing from the agreement. When presenting the investigation in court, the prosecution only spoke about the JIT in very general terms, but did not say anything in specific terms regarding the territorial investigative powers of the JIT. Basically, we were told that a JIT does not replace national investigations, but rather it forms the core of combined investigations. And within that core, the various parties which are carrying out investigations can coordinate their work and can share information and evidence. The parties can, of course, continue to fully investigate independently also. So, as far as we can ascertain, it was not established in the JIT that Dutch investigators could perform investigative work on Ukrainian territory autonomously and independent of the SBU, for instance. And this is reflected in the investigation overview document, indeed. And I'll be talking more about this later. Or actually, let me address that straight now. Indeed, it follows that in this case, the Dutch police was largely dependent on the SBU when it came to gathering evidence. And that prominent role of the SBU was described in that document I just referred to, the investigation overview document. And I'm going to give you a few examples of what that document says. Basically, what we learn is that the SBU, at a very early stage of the investigation, presented with great certainty contradictory launch sites from which a book was allegedly launched. First of all, a launch site to the north of Snezhnia. On the 25th of July 2014 at 10 a.m. local time, the SBU informed the Dutch intelligence service, the AIVD, of the following. Based on intelligence, the SBU posits that the deadly launch of the Book M was Lenin Street 20 in Snezhnia. At that address, there is a supermarket, part of the Fourchette chain of supermarkets. Behind that supermarket, there is wasteland from which the Book M was launched. Behind that wasteland, there is a mine shaft. Now, this information was received by the AIVD after the Public Prosecution Service asked the AIVD to look into gathering information on from where a Book M had been launched. So this means that within 8 days of the disaster taking place, the investigation was already targeted on establishing a location from which a missile that apparently had already been identified was fired. And that tactical information was shared with the SBU back at that very early stage. Now, once again, in a very early stage of the investigation, the SBU named a second launch site, and they named the place of Pervomaisky, which is located northwest of Donetsk. Now, let's be clear on this. This is not the place which is referred to in the indictment. Shortly after the information was provided to the AIVD, that's the Dutch intelligence service, the SBU posted a video on YouTube. That was on the 7th of August 2014, and that's the date on which the Ukrainian Public Prosecution Service signed the JIT agreement. Now, based on this YouTube video, what we have is a video that says that separatists had mixed up two places with identical names, and that is why they had traveled in the opposite direction with the book Taylor. It was claimed in that video that the objective of the separatists had been to shoot down a Russian civilian aircraft, and that the objective of the separatists, according to this SBU and YouTube video account, was that then responsibility for shooting down such a Russian civilian aircraft could have been pinned on the Ukraine. Now, the fact that this is put about by the SBU, this idea that a party would intentionally shoot down a passenger aircraft of their own side over Ukrainian territory to gain an advantage, calls into question quite considerably, to our mind, the SBU's working methods. Now, this scenario is referred to as the Aeroflot scenario in the case file. An officer from the Dutch National Police investigated that scenario and concluded that an attack using a book system from the location referred to by the SBU in the Aeroflot scenario was simply not possible, and indeed that the distance of 45 kilometers, which was set out on the mapping material provided in the SBU presentation, was simply wrong. So what the Dutch police officer concluded was that basically, well, we were being played for fools by the SBU. For reasons unknown to us, on the 14th of January 2019, so a good 4 years after that YouTube video and script was placed online, in very mild terms, it was stated that the scenario which had been presented wasn't plausible and contained an inaccuracy. And this was very, as I said, very gentle use of language when you compare the way in which calculations provided by Alma's ante was referred to in the investigation overview document. That those calculations by Alma's ante were simply logged in that report under the rubric of misleading information. And this is yet another illustration that the JIT did not treat all information received equally, but rather prioritized material that supported its own hypothesis. And thirdly, in 2014, the SBU stated that the MH17 had been shot down by two Buk missiles at a location in the vicinity of Yenekiev. Now, that information apparently had been obtained shortly after the disaster. And how that information was shared and when that would have happened is not stated in the case file. And the JIT certainly didn't further investigate that third possible launch site presented by the SBU. Now, it appears that the SBU, by presenting these various launch locations, and doing so early in the investigation, shows how unreliable that party is. Also, within 2 days of the disaster, they were placing intercepted conversations online, thereby establishing a basis for what was to become the later JIT scenario. Those intercepted conversations were accompanied by images which are somewhat troubling, so we won't be showing them here today. Now, of course, intelligence services are not primarily interested in uncovering the truth, but rather they are preliminary concerned with serving the interests of the country they serve. So we say that the fact that the SBU, over a very short period of time, already presented three contradictory scenarios should have made it clear to the Public Prosecution Service of the Netherlands that this was an unreliable party. One would have thought that they would be more careful in dealing with the SBU, but that was not the case. They should have understood that involvement of the SBU in this case could, in fact, jeopardize the quality and reliability of their own investigation. But they did not reduce their reliance on the SBU. Rather, they intensified and continued to work with the SBU. Indeed, they established a field office within the SBU in Kyiv. In that field office, Australian and Dutch police and investigative officers worked together. And with regard to that field office, what we know is that the objective of the office was to obtain information shared by the SBU and evaluated for analysis purposes. Any investigations, or rather any interviews which are carried out by an SBU officer, often accompanied by a Ukrainian prosecutor. Information which is received from the SBU by the field office is forwarded to the other members of the JIT, thereby allowing the JIT to jointly agree their strategy. And initially, telecoms data was first selected by the SBU before being provided to the MH17. And they did so based on telephone numbers and IMEI numbers of persons who were known to be involved in the armed conflict. Now that information was heard by members of the JIT office. Many of those witnesses were in fact listened in on by the SBU. It is unknown what the basis was for the selection of witnesses made by the SBU. Furthermore, there is a category of witnesses which were investigated as part of other crimes committed in the Ukraine, but were then considered in the context of the MH17 trial or investigation. Matters were looked into, or it is unknown whether they were offered any kind of recompense for contributing to this investigation in the MH17. As regards the intercepted telecoms, it is not clear to us that it seems that only the activities of the separatists were investigated at that SBU field office and not other parties. We read in the case file that the SBU only shared declassified information with the JIT and that other information could have been used for other purposes. In other words, in the criminal investigation, the SBU did not share all information which obtained. Now, the choice of the Netherlands to join hands so closely with the SBU, despite the lack of objectivity and the lack of reliability of that entity, gives one the indication that the Public Prosecution Service was willing to adopt the bias and that the separatists had fired at the MH17 and not another party. In so doing, the prosecution failed to maintain sufficient distance from specific lines of inquiry. They failed to keep their mind open, and they failed to take into account other factors which could have been equally illustrative. The prosecution itself admitted that if the Buk missile administration was correct, and such a situation could have been true, they stated that the missile might well have been a Ukrainian missile. The prosecution says, however, that this did not seem to be in line with the forensic investigation because there was more in common with a modern than an older missile. And that is why it would have been so important that professional independence, notably with respect to the Ukrainians, had been maintained. Furthermore, there was intensive work with the SBU, but not with the Alma's anti-experts. At least the Alma's anti-expert was not included in the expert team. Now, of course, one understands why the prosecution may have done so, because it would have been even more difficult to gather evidence on Ukrainian territory without doing this. The Dutch authorities had to choose between two evils. But we feel that they should have placed more importance on their independence than they did. And this is the reason why the defense has constantly asked the prosecution to provide the basis for the choices which they have made. We have also tried to understand more about the provision of information, the sharing of information by the Ukrainian authorities, and the role of the field office in the JIT. There is an official report regarding the way in which this was done. The Netherlands has not received, or the defense has not received the answers which it has sought, although it is extremely important to obtain the answers in order to better understand how this investigation was conducted. The defense has not been served as it should. We have not been able to gain the information which we wanted regarding the role of the SBU in this investigation. Now, when it presented its prosecution case, the prosecution congratulated itself and the JIT on the way in which it had verified material gathered in this case and how it had been compared to other material. They said that they had taken extra steps to be extra stringent in their analysis and verification of information received from Ukraine. We do not have the impression that the work was done any better in this case than any other. One would, of course, expect of the Public Prosecution Service that it always do its work in a detailed and conscientious fashion. However, what the prosecution said is that indicates that the prosecution would have preferred to have had full oversight of the investigation in the classic way that they would when working at home, but that this was not the case here.
There was a very important part played in this by the SBU regarding what has been published in the last few years. The corresponding articles, for example, describe whether it is desirable for the SBU, in addition to its intelligence task, also to have an investigative duty, and whether the monopoly of telephone taps really should lie with this agency. From these articles, we can see that these questions are justified and are related to the fact that, according to Western standards, there are serious misgivings about whether we are talking about a fair judicial system. The many indications of corruption are important here. Justification from what I have just summarized is set out in Annex 1 to the pleading notes, and I won't read them out. But I will make them available to the Registrar and Prosecution, and our request is also for this to be made available to the Council for the Relatives in accordance with our agreements. In Dutch judicial process, as we are all well aware, all the circumstances I have listed, whether explicitly or not, are strange and unfamiliar when we talk about our investigative authorities. Now, what you doesn't know don't hurt you, but when assessing the evidence which is overwhelmingly provided in this case by or through the SPU, we cannot overlook it because of all the interests at play in this case. We can't simply have confidence that the sources of evidence made available to us are reliable and full. In particular aspects of our pleading, we will come back to this issue where required. Well, that brings me to that section of my presentation. Might this be a good point to stop? Yes. Yes, I think this is a good opportunity to break, and then we can make the copies available. Yes, it's rather an unusual day, because the introductory words took quite some time. That won't be the case in pursuing days, and we will therefore stick to the timetable. But now we'll have a break. It's now 11:30. We'll start again at 11:45, quarter of an hour's break. Quarter past 12, 3/4 of an hour.